difficulties. So the idea is to provide a structured approach to damage estimation in competition and IP law, help you to navigate expert opinions by understanding what is acceptable economic methods, and illustrate few key economic concepts that are important for that ensure that damage estimation is reasonable and justifiable. This is the structure of the lecture. I will be very short on the legal basis, and I will spend a little bit more in the third part on the counterfactual analysis, the core economic principle, because I think is what I can contribute more here, and something obviously also on main methods of economic damage estimation. Anyway, the legal basis is for antitrust. Clearly, there are the court decision we have discussed other times, but the legal basis essentially now is the damage directive of 2014 that is based on the idea of the right of full compensation. The injured party should be placed in the position she should have been but for the infringement. That's the idea. So the idea is not, or there is an explicit prohibition of overcompensation, no punitive or multiple damage like in the US. Full compensation, that's the plan. The damage components normally are three: actual loss, danum emergens, the loss suffered by the injured party, the loss of profit, the lucrum censans, and the payment of interest if there is time between the damage and the compensation. There are situations, however, in which there is a compensation of the actual loss that need to be done at multiple supply chain levels. Upstreams, downstreams, there are a movement of the price. And the idea that this should not lead to overcompensation, Article 12.2 of the directive. So there is this idea to use the concept of understanding the passing on of the damage to other level of the chain, so that the actor that is able not to pass on to something else the damage shouldn't be compensated for the damage that is not suffering. I will discuss this a little bit more in a while. Which instrument we have? Well, we have relatively good instruments here because we have this practical guide from 2013 that is a good tool on damage quantification written by the Commission and helps to understand which are the main recognized tools that can be used to damage estimation. And this helps you also to see if the experts on which you are seeing that are using a line of explanation that is acceptable and standardly recognized. So it's a good contribution. There is also a contribution of July 2018 that is the draft passing on guidelines. They are in the same idea. They are the same, are the evolution of the practical guide to the issue of passing on. I think they are less slightly less clear and slightly less effective, but probably is my low sympathy for the passing on concept and use. But I think that anyway, the logic is the same. And the logic of all these documents is to identify the key economic variables, the trade-offs, and understand which are the main economic methods that can be used. The legal basis for IP damages instead are in the APR enforcement directives of 2004. The first idea is again the principle of full compensation. But here is slightly different because full compensation is a sort of minimum standard. The remedies provided the directive don't preclude application of remedies more favorable to the right holder. So while full compensation is the whole thing in antitrust, here full compensation is the minimum standard proposed by the directive. The damage components, here the damage components are again the actual loss, so what is the loss suffered by the injured party, including lost profits, like in antitrust. Um, Eventually, however, this can be estimated through a lump sum damage based on the hypothetical licenses royalty or licenses fee. So there is this idea, and we'll discuss it later, that in antitrust cannot be there, obviously, of what would have been obtained by the holder of the right if the right had been fairly negotiated. So you see, it's a nuance, it's a tool somehow, and a way also to look at the concept of the damage. Obviously, there is another possibility that is working on the unfair profit made by the infringer. And you see, this is very different from antitrust. We'll discuss it later, because the unfair profit made by the infringer is not a concept used really in antitrust. And probably this is an element really of diversification among the two. And plus, this, in antitrust, this is not there. There is the possibility of moral prejudice caused by to the right holder by the infringement. Okay, remedies shall be fair and equitable, Article 3.1. And remedy must also be effective, proportionate, and dissuasive, and shall be applied in such a manner as to avoid the creation of barriers to legitimate trade and provide for safeguard against their abuse. So you see, this idea of dissuasive relates with the idea that full compensation is a minimum standard. Yes, there is a possible idea of some punitive, some going a bit more than the damage in dissuade. Okay, these are more or less. The guidance here is less structured. We don't have the two nice documents I mentioned for antitrust. There is a European Commission guidance on enforcement of intellectual property rights that try to clarify the scope, the rules for obtaining and preserving evidence, and some general guidance on injunction and calculation of damage, but no details on specific measurements. I would arrive to say that the guide we have, the practical guide and the other guides that we have in antitrust could be used as reference points when they apply in the absence of specific reference points for IP damages. Okay, the type of damages. Well, the damage liability in antitrust have Article 102, as we know, have direct effect. So the market participants and then the consumer also have a right to undistorted competition. So the breach of this article entitles the injurious party to compensation, and the infringer are subject to damage liability. Which are the main types of harms? Well, probably the two main types of harms are the cartel price increase, when there is agreements that raise the price, companies get together and raise the price fixing, market sharing, output limitation. The form could be different, but the idea is to raise the price. And this translates in this idea that there is an overcharge, an unfair addition to the price that is paid by the consumer or by the company that is buying the good. And these are very common as follow-on action, by the way, because often there is a decision of some competition authority that has realized this cartel as a persecuted cartel, and so this could be follow-on action with all the implications that I don't have the time to discuss today, or the relation between this decision and your judgment that we have discussed in other occasions. Then there are other kind of damages, consequence of exclusionary abuse of dominance, in which there is raising rival cost, reducing rival income, margin squeeze time, this kind of behavior from a dominant firm that damages another firm, is a competitor. This could be foreclosure, loss of business, and sometimes there is a decision of the competition authority, and sometimes there isn't. Sometimes these are really standalone action. When they are standalone action, clearly they are more difficult to be built in terms of evidence and so on. But there are also action of this kind. Obviously, exclusionary abuse, calculating damage in exclusionary abuse is more difficult than calculating damages in cartels and price increase. Then even more difficult, there is a decrease in quality, slowing down innovation, this kind of accuse of damages because of this kind of more sophisticated behavior. And actually, these are difficult even for public enforcement. They are more difficult even for public enforcement, but these are not, I'll mention, but it's not the topic of today. In IP damage and liability, we have a series of sources that I listed here, direction, regulation, and so on, that brings essentially from patents, trademark, this different kind of interest that can be violated, different kind of rights that can be violated. Normally, the type of harm is slightly different. In patent infringements, we have two major dimension. One is the loss of profit. If sales are diverted to the infringer, the owner of the right of the patent doesn't manage to sell what he could because the infringer sells part of it. Or price erosion, if the fact that there is an infringer that force a patent holder to lower his price. And these two elements are normal consequences of patent infringement. In copyright violation, we have lost licensing revenue if the infringer if infringing use bypass market transaction, or market substitution effects when there is piracy and the fair product, the legal product is substituted by this illegal, by piracy production. And then there is a trademark violation in which, again, we can have lost profit and also reputation damages if the trademark is weakened by the infringement. Okay, let's go to some economic principle, but maybe even more than economic, logical principle. How can we estimate the damage? We have an infringement, be in IP or be in antitrust, we have to try to understand how much is the damage that this infringement has created. Well, there is only one logic step, that is to imagine and to describe a counterfactual situation in which the infringement hasn't been there. If we manage to describe this situation without infringement, then we can take the difference and see what the infringement has caused as a loss, as a damage, what have been the real consequences. So the idea is compare the actual outcome with an hypothetical scenario in which the violation didn't occur. Clearly, this is the whole difficulty of this game, and the consequence for the subject is that the injured party should be put in this position in which the infringement hadn't occurred, so a but-for position. Okay, so the way in which we calculate this damage, this D, capital D, is the difference between economic variables normally, price, sales, profit, whatever, we'll see, between the counterfactual and the factual situation. And this difference is what we are aiming at. This difference tells us what could be the damage, how to calculate the damage, how to measure it. Clearly is a logic and a mental exercise. I don't want to, I always arrive to this kind of slide and we have to discuss it. It's very simple, but still is bothersome in so many ways. But let me be very, very simple here. Okay, the idea, if we are talking about a price, is very simple. If because of a cartel, because of anything, you have a factual price, an infringement price that is higher, you have two consequences that are obvious. the price is higher and the sold quantity will be lower, okay? If you are a buyer of this good, you'll buy this good at a higher price than you should, okay? So the difference between the high price at which you buy and the lower price at which you should have bought, that is here, this area A, this difference is that the overcharge, what you have paid more. Then there is this strange triangle, the B triangle. What is telling us? It's telling us that because the price has been higher, there have been people that did the unit of the product that have been sold. And that's a loss for society, if you want, because there was the possibility of a deal of buying that product at that price, but the price was higher, and so certain deals weren't done. This is called a deadweight loss. It's a loss for society. In a very abstract way, I wouldn't underline it completely, but in a very abstract way, one should think to the A area as the area of the overcharge that should be compensated by you, by the damage action. Probably the B area should be the area that should be the area of the fine. The public, the antitrust that intervene there, find the cartel, should at least, if you want to bring society back to the same situation somehow, should at least find them for B. Okay? That could be a way to really fully compensate society. The A square would compensate the damage of the buyers. The B area would compensate, the B triangle, through a sanction, could compensate the loss of society, okay? But that's is not the way in which we really, I mean, in some way, probably is the way in which we go in Europe, let's put it this way, because we normally have in cartels, in particular, sanctions to the cartel. So you could think to this in this way. This other graph has a different logic, but the idea is the same. Look at this. The A area is the same as before. You have paid a factual price that is higher than somebody has paid a factual price here that is higher than the counterfactual price, okay? And so the A area is something that should be, is the damage that should be compensated to the guy that has that got the infringer. But however, here there is this passing on idea, the idea that the buyer that has lost this A area, however, is somewhere in the chain of production and is selling to somebody else's product and manages to raise his own price, okay? By raising his own price, in a way, he managed to reduce his damage, okay? Because he doesn't take the whole damage. Part of the overcharge is passed through the production chain. So we have this area B that we consider this rectangle, that we consider a sort of, if you want, a compensation caused by your action, okay? So you lose A, but you manage to get back B by raising the price to your customers. Obviously, your customers could go to a cause, to legal proceeding and say, I've been paying too much. My price has been higher because of the cartel, okay? So they could be part of the legal proceeding. But that's another story because it's difficult and very rarely happens. However, there is a second element that you have to take into account, and this is a new element, this other rectangle C, because if you raise your price, and you buy a good with the overcharge, and then you raise your price to recover at least part of this overcharge. However, you lose, economics tell us that you lose sales, okay? You lose the sales, and so you have what is called a lost business or lost volume effect, okay? And this also is classified here in this rectangle C. So your loss becomes A minus B plus C, okay? You see, this is why the passing on idea complicates the life of everybody. But I'm not saying that it's not as an economic sense. The small triangle there, the triangle, remains again the loss for society, because society anyway loses because there are less deals than should have been if the infringement wasn't there. So you see, if you have a situation in which there is a chain of production and the infringer raised the price, but the company that buys from the infringer at the overcharge managed to pass part of this overcharge to somebody else in the production chain, he reduces his own direct overcharge, but he loses business. And we have to calculate A plus C minus B. That's the general idea here. And this, I have to say, this is the general idea of the directive. It's very clear. That's what we have to do, okay? I often mention, I don't have much time today, but I often mention that, for instance, in the US, this doesn't work. They don't do this. They say that this thing of the overcharge is not, this thing of the passing on is difficult to calculate, difficult to do, and anyway, it doesn't make much sense. So they simply don't use the passing on concept. If you have an overcharge, you can get back in damage the overcharge, the loss that you have undertaken. Obviously, the consequence is if you are somebody that has bought from somebody who has raised the price because of a cartel, you cannot go to court. There is no second level, okay? There is only one level. This view is very pragmatic and is based on the idea that at the second level, almost nobody goes to court. It's too difficult, too far. And so it's a question of difference of view. But our law is this one, okay? All this looks relatively simple when we are talking about raising a cartel, groups of firms, raise the price, you have an overcharge, that's clear a damage, you go there and get the damage, okay? You calculate the damage. It's a bit more difficult, but still possible for exclusionary practice, for behaviors, abusive behaviors and things like this. Because then it's more difficult to capture all the nuances of the behaviors, what would have been done by the competitor if the infringement wasn't there. There are much more, the counterfactual becomes more speculative because you have strategic players. Is a little bit, if you want, like when I was discussing the overcharge plus the passing on. No? You have strategic move, at least a strategic move. So now the guy that got the overcharge still can make a move to raise his own prices. Okay, here is the same idea, but more complex, because one firm abuses another firm with a margin squeeze, with a time products, creating a problem to the firm. But still, there are a lot of relation between these two competitors, and you need to understand how to calculate the damage. But again, the major message here is that you can do it. You have to build a counterfactual in which the abuse is not there. And from that, trying to derive a damage calculation. It's a bit more difficult, much more less clear that in a cartel that there is a price, but still is possible to do. And the practical guide of the Commission helps also in this direction. If we move to IP, here the things get a bit more. The deep idea is the same. You have to build a counterfactual. Okay? So what happens if the infringement is not there? Okay. Lost profit, for instance. A movie is pirated. There is a movie and there is a pirate that sell the movie without having the right. Well, how many legal copies could have been sold in the absence of the piracy? There is a trademark that is infringed. How many customers were misled and would have preferred to buy the legitimate brand? This is the question of the counterfactual. It's again a question of removing the infringement and try to understand what economic difference this would have created. As I said here, we have this different possibility. That is the idea of the hypothetical licensing fee. Instead of going in the direction of removing the infringement, you could go in the other direction in a sense. What if instead to make the infringement, the infringer would have gone to the right holder and offer to buy the right, to license the right at a fair price after a negotiation? You see, you have a different avenue of estimation, if you want. No? One is removing the infringer, and the other is transmute the infringement in a legal fair behavior. What would be the answer? So in IP, we have this different possibility. Obviously, this possibility, however, and I want to underline this, is a lower bound. Why? Because the hypothesis behind this is that the legal holder of the right will give the license. So you are obliging him to give the license, okay? Maybe he didn't want to give any license to the infringer. So you see, it's a lower bound, but this in certain situations can be useful to estimate, or at least to get closer to the estimation. Okay, in copyright cases, sometimes you have more indication because think to cinema, movie rental, streaming subscription, because you have it's a bit easier because you have a counterfactual price that is the legal price, okay? The legitimate price of the product, and that is there normally. Then we have a counterfactual quantity. How many illegal uses have been done of the product, illegal same, illegal streams, and so on, if it's a movie and so on. The only doubt here in the US jurisdiction, this is more clear, is that you have not to overcompensate. You have to also estimate somehow what portion of this illegal behavior could have been really illegal behavior. How much translates in illegal behavior? I mean, if somebody pirates a movie, is not 100% sure that he will buy the same movie at a fair price. He may or may not. So you see, this sure.
In competition law terms, this would be an issue of relevant market definition. Is the original IP protected product in the same market as the infringing product?
Yeah, yeah. In a way, yes. Anyway, this calculation can be done, and sometimes is obviously is as the very thing we are discussing today. These are estimations, so you have to estimate something and use the better methods to have. You'll never have a certainty of how many people that are pirates that are pirating a movie would have really bought the movie at the legal price. You have to estimate this, but anyway, that's the idea. In patents, is a bit more difficult to estimate the loss profit because there are more nuances. Because first, you have to understand really how much the patent differentiate the product respect the invention. Sorry, the patent invention differentiate the product is different from other things. Which substitutes are in the market? What is the level of market competition? So in patents cases, we are really closer to antitrust in a sense, because we have to look also at market confrontation more. In trademark cases, we have this other element that lost profits depend also on brand confusion or other elements that are and to the extent in which the infringement divert the sales. So in trademark cases, we have also this moral ground that needs to be evaluated, that in fact is in the law indicated. Okay, let's go quickly to some method of estimation. Okay, in estimating the actual loss, what could be the overcharge or something similar, or also the lost profit, that is the loss of revenue of sales that you have in consequence of the infringement, we have a series of methods. They are all in the practical guide, for instance, in competition, they are clearly indicated. Comparator-based, cost plus, simulation, and finance-based method. I will mention them quickly, but only one is really continuously used, and is essentially the comparator method. The others are much less used for good reasons. I will explain. In lump sum royalties, this idea that you could estimate one number, the right royalty in IP cases, you have to look at three elements: the firm comparators, the market comparators, and also the result of an hypothetical negotiation. So these are the elements. In unjust enrichment, in patents, copyright, and trademark, you have accounting methods that should be used. Let's go a little bit to the comparator methodology. I don't want to go deep in this, but I want just to get the feeling of this thing, the logic of this. As I explained before, the logic, and by the way, this is the method that is preferred by the practical guide. It's clearly the king method at the moment, comparators method, comparator-based methodology. So we have essentially what we are looking for. We are looking for a counterfactual in which the infringement is not there, okay? So how can we build a counterfactual in which the infringement is not there? This requires that we take out the infringement, but we have to be careful because we have to take into account everything else, okay? We want to identify only the effect of the infringement, okay? One method that is used when it's possible is a before, during, and after method, in which you compare, for instance, let's say that we are discussing a cartel, no? If we have, you can see here, we have a competition authority tells us that the cartel has raised the price, okay? And then we have the price before, a series of price before, and a series of price after. Well, a before, during, and after method try to use the pre-infringement cases. Here the infringement wasn't there. The post-infringement data, the prices afterward. Try to understand what the cartel has done. So the idea is to isolate, by the way, I take this from the practical guide, the commission that has designed this. You are trying to isolate the effect of the cartel. You know, this can be done also in a very elementary way, if you want. No? I could take an average year, and do an average year. And this difference is the cartel effect, okay? I don't advise to do something so simple, but gives you a feeling, okay? A graph like this, obviously is built by the commission, but gives you a feeling of what we are looking for. We are looking for a situation in which we think that the price, that this is the factual price, and we think that the counterfactual price would have been, yeah, not a straight line, obviously, but around here, okay? If there was no cartel. And that's what we are looking for. And the difference between this price and this price, this average price and the average price here, is the famous overcharge, okay? The loss that you had because of the action of the cartel. There are other Okay, the general idea is the one I showed, but sometimes you don't have enough data. Let's think a cartel that is very long, okay? It's very difficult to measure before or after is too short. Then you could use a benchmark or yardstick method. That means you don't use the same market as in this. You don't use the help of the time that I used in the graph that I just showed, but you use instead a market, a product that you think is similar and in which there was no infringement. And you look at as that product moves, a benchmark product, respect to a product that was cartelized, okay? Or you can do both things. What is called a difference in difference method, in which you mix the time and the benchmark counterfactual, and you try to derive something that is an affected product or geographical market during the infringement and the other period. Let me show you in a second the other. Okay, this is, for instance, a comparator method in which you look at another market. Okay, these are this is the but-for estimated price. This is the benchmark, the cartelized price, and the difference is the overcharge. Still, the same idea, difference in difference method. You have to, these are, by the way, these are just, I'm showing you the sample, but I invite you to go at some point, if you need to use it, to go to the practical guide, and you'll find exactly this example explained, okay? So you see, but the idea is always the same. You want to see what the effect of the cartel has been. Okay, let's assume that there is inflation, that the price is going up anyway. Well, you want to see what only to isolate only the effect of the infringement. Okay, that's the idea. Okay, that's the concept. How do you do it? Okay, let's keep in the. Let's think to this one. Okay, that is the simplest one. How can you do it? What are the tools that you can use? Before I suggest the most elementary tool. I took an average year, I compare. I took an average year, an average year, an average year, and this with the cartel. And this is the overcharge. And this is a simple difference of two averages of prices. The overcharge is 20%. I don't know. It's very simple, probably too simple. Okay? So average values, linear interpolation, these are simple methods, can be useful, can give you a first idea, okay? But what is the problem here? Well, the problem is that other things can happen at the meantime, in the same time. For instance, if there is a rise in inflation, or there is a rise in an input, okay? You are looking at that, you are looking at this and saying, okay, that's the effect of the cartel. But if here there was a sudden rise in the energy price and affects my good, that would lead me to the wrong solution. I would assume that all the fault is from the cartel, but no, part was a cost raise. Or if there was inflation, I have the impression that the price went up because of the cartel, but it's not like this. There was a general effect. So that's why we normally, and the Commission suggests, to use regression analysis. What does regression analysis? The regression analysis is a tool that allows you to get control for other factors. So you put in this regression analysis all the other factors that you reasonably can have an effect, and you shouldn't worry too much if they don't have an effect, because if they don't have an effect, the regression analysis will tell you that they don't have an effect. The coefficients of the analysis will be zero, will be not statistically significant. And then you have the cartel, okay? The period of the cartel. You put there this element in your regression, and if this element has a statistical significance, it's telling you that the cartel had an importance. If you regress everything in logarithm, we'll tell you, that's the magic of the logarithms, exactly the percentage of which the cartel in that model has raised the price. But just to, anyway, I don't want to push it too much, but somehow what I'm saying is that if you build a regression, or the economists that work in the case with you, or for the parties, and you can check and compare, build a reasonable regression, you'll see that you are controlling for other things, and you can see the direct effect of in this case, of the cartel, or other behaviors if we are dealing with other things. Cost plus methodology, this is used sometimes, is more simple, but the idea here is to look at how much the price has been raised, and then compare this with what could have been justified, but only the raise of production cost, a reasonable markup. This can be done. The problem is that there are a lot of elements that create a bit of confusion. First, what is a reasonable markup is not something that, if we discuss it, we may not agree about the right percentage in any industries, may be very different. A good markup, if you have a department store, probably is 2%, but if you sell cars, probably is much higher. So there are a lot of differences. Then you have to decide what kind of cost, what to do with the common cost. If it's a multi-product firm, is a nightmare. I mean, it's difficult, but sometimes there are situations in which this can be used, particularly if you have behind a regulated industry in which you know a lot about the cost of the companies. Then could be a way to go. And the Commission suggests as a possibility. Simulation methodologies, I don't even mention it. Commission mentions it, but I don't think nobody believes, because the idea is that you design the equation of how the economy works, and that's too difficult. You don't have the data to do it normally. But anyway, in theory, if you could design a perfect world, you could compare with the real world. Let me underline that it's always the same story. It's the counterfactual. You design a perfect world and compare with the real world that is not perfect because there was the cartel or the infringement, okay? But this is a method that is not used. In certain cases, a finance-based methodology that looks at share price, losses of the shares, and so on, could be used. It's very rare and very difficult. But one thing in favor of finance-based methodology sometimes is the fact that you can use public data. And generally speaking, in any estimation of damages, if you can use public data, it's better than if you have to look for private data that are unreliable and interested normally to be given in one direction or the other. But anyway, also this is very rare. So the comparator method remains the main, the comparator method remains the main method that is used for damage estimation. We were saying that in lump sum royalties, in licenses, for instance, this idea of could we have a sum, what I discussed was obviously antitrust. Now let's move to this different possibility that is offered by the IP world. Could we decide what is the right royalty if there has been a royalty? So we remove the infringement in another way by saying, okay, what if he pays? How much should he pay? And then it's a bit complicated because first we have the issue of understand what he should pay. So what is the validity of this, for instance, if it's a patent, how much is worth to license this patent? And so you first have to be sure that the patent is valid. and then you have to understand how much could be worth. Then can you look at other patents? That's a good way to improve, to estimate this. But if you are discussing a single patent, normally patents are not sold by single patents. They are sold by portfolios. There are thousands of patents in a portfolio, without talking about a standard in which there are even more. So this method is not simple. Sometimes can be used. Sometimes can give you an indication. I will come to this better. But anyway, what are the issues if you try to measure by a lump sum what would be worth to license that patent? Well, then you have to understand at least three things. What the patent is adding, the technology, what could be the use of this patent by the infringer, what are the general economic conditions for using this patent. And so you should look at similar things. You can go for market comparators. Only here is a bit more difficult because while when we compare one market with another and say, okay, this market has a cartel, this doesn't have a cartel, but the price in the markets are normally well known, okay? So it may be difficult to be sure that the second market doesn't have a cartel, but the price of the market can be relatively easily understood and identified. While in IP deals, most of the deals are confidential. It's very difficult to find the right, at what price a license was sold, or a similar license could be bought, sold. It's not easy, okay? So you see, that's why the method is intuitive and is also nice in a certain way, because it would be the compensation. As I say, it's a minimum, but that would give you a nice minimum. But the information often is not very good. While it's better, for instance, if you are discussing a situation in which somebody is pirating a movie, as I mentioned before, because there the price of the movie, you know, the price of a theater ticket, we know. So there is more clear. If you go to a patent, it's much more complex. Okay, but this idea is there and sometimes can help to make an estimation. And then there is a final point that is an interesting point, really, and this, okay, let's assume that we want to define a fair royalty, okay? Somebody has infringed my patent, we want to understand if he had paid, how much we would have paid. Well, you have to assume that there would be a negotiation. And then you have to, as I said, you have to understand the value of the IP right for the infringer, how much would he be willing to pay, how much is the value of the IP right for the right holder, would be willing to license, at which price, and then there is still an issue. They would negotiate. And what would be the outcome of this negotiation? Because not everybody can, I may want to buy something at a price, but then if I can negotiate, I'll try to spend less. I may want to sell at a price, but if I can negotiate, I try to get a better price. And so this negotiation where, how the gain of the negotiation, that is the core of the business, will come out. Well, there is a 50-50 rule of thumb, sometimes in estimations, and in more sophisticated ways, a Nash bargain solution, we split in half. And in the US, sometimes they talk about this 25% rule of thumb. So the patentee should receive 25% of the profit. These are rule of thumb, obviously. But anyway, this is another complication, okay? But still, the problem here, as I said before, is that we have less guidance from the Commission. Probably they should write something more on this to try to help to do estimation. So anyway, how can you try to do a bit better for estimating the value to the infringer? Well, you should look at the substitutes. If there are many substitutes of this patent, the value, the probability, the willingness to pay is very low. Okay, so that patent, that element would be of very low value. If there are imperfect substitutes, then the question is what could be the incremental profit or the cost of the best similar technology. Not easy even this. Or if the technology is already licensed to somebody else, then the question is that it could be also lower the incentive to buy. Anyway, the key principle, the economic principle is that the maximum payment equals the benefits over the best alternative. Okay? If my best alternative is close, I will pay very little. If the best alternative is much worse, I will be, in theory, ready to pay much more. Okay? This is the value for the infringer in the hypothetical attempt to fix a fair royalty. The value of the IP holder, okay? I remember we are talking to a situation in which we are somehow imposing to IP holder to deal. He probably wouldn't have liked to deal. He's dealing because we are calculating the damage that is already done by the infringer by imposing him to see what if he had sold. Okay. Then there are some nuances. The first is, would be competing with the infringer? Well, if he's not competing, then any money that gets from the giving the patent, giving the license, is incremental profit. And then is an element to take into account, okay? So the expected royalties would be lower than those that you would ask to a competitor, because a competitor would take a sales against from you. While in this case, if you are not competing in that market, you don't lose any sale and you get some revenue, okay? What if I'm a right holder that competes and doesn't license? I don't want never to give a license, okay? Well, then it's not enough that you compensate me for my losses, okay? Or for the fact that some of my sales will be done by somebody else. You have to give me more, because I wouldn't license, and the fact that I'm obliged to license, let's say, that by the infringement that has already happened, creates the fact that my price will go down, because there will be a competitor that wouldn't have been there. There will be what is called a price erosion, okay? So this is another element that increases the value of the damage, increases the value of this hypothetical remuneration through a lump sum, through a fair negotiation, let's put it, okay? So these are the elements. If the right holders competes or not, and if the right holders wants or not to license. And you should be aware of these realities. And these realities, by the way, are market realities. He compete or not in the market is a reality. Is somebody who licenses on technologies or not is something also that you can know, because it's a behavior that is in the past and in the reality. So these are complications, but are useful to understand. Then there is a question of unjust enrichment. That is a criterion, however, that is more legal, probably. It's difficult to find a strong rationale for this. The idea here is that you don't want that the infringer gets this unfair profit. Let me say one thing about it. So you have to be careful about what happens. To this. Let me say a word about unjust enrichment in the case of antitrust. Let me bring a second parallel. There we are less careful on this. all this passing on story that I discussed before is a story that avoids the issue. Because let's assume that I am a cartelist. I raise my price, okay? You are down the road. You buy my price and you pay the overcharge, and I get the overcharge. Then you pass on to your consumers. This is a way in which I reduce the damage because I say, okay, you have, let's say that you have paid 100 of overcharge, but 50 you manage to give to your customers. Then your damage is only 50. Yeah, but the guy that has raised my price, the overcharge, keeps the 50. So there is an unjust enrichment recognized by the law, unless somebody there that has paid the second level rise comes to the court and says, because of your cartel 2 steps below, I have lost, I've paid too much. And this never happens. So you see, unjust enrichment is an issue in IP law, but is not taken as serious in antitrust. And this, I think, is, again, a discrepancy of the story. But for the moment, the law is like that. Okay, very quick on the practical considerations. What you should do when you evaluate an economic report? Well, you should look at the assumption, ask if these assumptions are realistic, if there is a comparator, are these comparators good? The benchmarks, if you are using another market, is really similar. This is the issue. Okay, is the methodology strong? Is the methodology, did the expert uses other methods? Can move a small assumption and would change everything or no? So there is a robustness in the estimation that you are seeing. The data are reliable. For instance, public data are better than private data because private data we never know. Is the data complete? These are the questions that you should ask. As I say, sensitive analysis. Can you ask the expert to do another estimation with small changes to see if that is consistent, what is doing? Is the time frame right? If I move a little bit at the time, things change too much. These are the issue also. Is the report that I'm receiving as a judge is clear, is understandable, is reproducible? If I give it to another expert, can come back with the same result or no? If it cannot come back to the same results, that's not particularly good. If I name my own expert as a judge, and the expert cannot come back with the same result, there must be something that is not good in the data, or it's not a good expert, but anyway. So these are the question that you should ask yourself. In damage estimation, normally the mistake would be having an inappropriate counterfactual. Obviously, building the counterfactual is difficult, so that's where the attention should be put. Another typical mistake could be ignoring other factors. As I tried to explain to you, a regression is better than an average because a regression can take into account other factors, okay? In patent and copyright cases, you have to be careful on overcompensate or undercompensate damager. What is the real value of the technical improvement that is embodied in the patent, for instance? Would the infringer really would have paid a legal, all the infringers would have paid a legal product? That's another serious question. The effect of price erosion. Price erosion could be a serious thing because the infringer could lower my legitimate price, but I cannot sum things, okay? If I take one piece, always in damage estimation, one has to be careful not to duplicate the damages. So there should be an economic logic in the damages calculation. So in conclusion, there are similarities. I wanted to today I wanted to underline more the similarities. And the similarities, except for this concept of the lump sum that is typical only of the IP rights, the similarity is that you have to think to a word that wasn't there. Is a counterfactual word. This counterfactual word is a word if the infringement wasn't there. And the comparison between this word and the factual word is the basis to understand what is the damage and to calculate the damage. And this is true for almost all the damages calculation. The methods to estimate this counterfactual variable of interest, the different price, the different volume, the different profits are essentially logically and technically similar, both in IP and antitrust. And by the way, these methods have very much improved in the years. You should trust methods, economic methods, because they've improved. If the data are, if people comes with a good method and with good data, the estimation is much better than trying to guess what could have been the damage. It's much better. And the Commission is telling us, use the methods and giving us guidance for this. So in both situations, the key question the judge may ask to the economists are similar: clarity, robustness, precision. Where did you get the data? Are public? How can I be sure that the data you are using are all the data that you need? These are the questions. And so in the end, some of the differences that remain are differences that are somehow in the law. The objective in one case is restore competition, in antitrust is restore competition and avoid overcompensation and give only full compensation, while in IP is protect the rights, and there is an emphasis on avoid the unjust enrichment by the infringer that in competition we don't have at the moment. The economic harm in antitrust is the overcharge, the fact that the infringement raise the prices or make lost profit for the firm that is for the consumer or the firm that is damaged by the cartel or whatever. While in IP, we have lost profit, we can have also price erosion, the fact that my price is reduced by the existence of illegal alternatives. So you see the difference in prices more, probably is in different direction normally between IP and antitrust. And there is this additional tool of the reasonable royalty. With care, but is a tool. The complexity is that the counterfactual price need clear benchmarks, and you have to find the benchmarks. In the counterfactual in exclusionary conducts is necessarily more complex in antitrust, but still can be built. In IP law, the counterfactual price and quantities in copyright are easier because normally you have clear, the legal prices are more clear and are based on clear benchmarks. Is more speculative and more difficult in patents and trademark because there more variables need to be reconstructed. So it's a more complex thing. But still, as in exclusionary conducts, you can do a good damage estimation. Obviously, you can do it also on patents and on trademarks. So finishing, the complexity is less when the things are more clear. In cartels, the complexity is less. The overcharge is more clear. We have created some complexity that I don't like with the passing on, but the overcharge theory is clear, okay? And in copyright also things are clear because the starting price, the legal price is clear. You have the infringement, but you have also a legal point of reference and you have a reasonable quantities. There is this issue a bit thorny of understanding who would have bought at the fair price and who wouldn't have, but can be dealt with statistics somehow. It's a bit more difficult in exclusionary conducts and is more difficult in patents and trademark. But you see, generally speaking, this idea to reconstruct a counterfactual scenario and compare it to what has happened because of the infringement is the key point. And this, in the end, is even before the economics is logic and can be done. And economics helps to bring the tools for this. Thank you.